Good morning, ladies and gentlemen, esteemed guests. Welcome to day 2 of the Nuremberg Forum. It's the part of the forum where we really do delve into the more material, the more substantive parts of this theme of legally undeniable criminalizing genocide denial. We will start our session off today with panel 1, titled Denial, the Facto, the Jure, and in Doctrina. What we will have here is really a deep dive into the concept of denial. How should we understand it? What is it? Is it, as the Americans say, a content violation? So basically an opinion that one can have, and it is legitimate to have one, even if objectionable. Or is it, as a European scholar might prefer to say, something filled with racism, xenophobia, and a form of hate speech, a continuation, what starts off perhaps as incitement to genocide. Well, these are the things that we will be discussing in panel 1. Your moderator of choice will be a colleague of mine, Kiran Mohandas Menon. He is a senior officer here at the Academy, and we are glad to have him as our moderator. Now, before we start, there's a particular component to our forum, and as you know, our forum is also available online. And people online, as well as those in person, can submit questions, also online via their phone. And we will have a motion. Every panel has a statement. For this, I asked the people online to check the side panel next to the stream. And for the people in person, on the back side of your brochure, you will see a barcode that you can scan. I would now like to present the motion. For our first motion, we will have anti-denial laws unjustifiably infringe upon freedom of speech. The poll will be open throughout the panel, and we can vote now. At this point, I would like to refer back to my colleague Kiran. Feel free to keep voting, submit questions online, and thank you very much.
Thank you very much, Alexander, and good morning, everyone. Welcome to the first panel of this year's Nuremberg Forum. So yesterday we heard powerful evocations on the courage of contemporary witnesses and individual survivors as they honored the memory of victims and dedicated their lives to countering genocide denial and furthering prevention and education. We also received poignant reminders of the pervasiveness of genocide denial and of how denial can prevent societal healing and aggravate historic fault lines while confronting both the historical record and human dignity. Now, with these discussions fresh in mind, the first panel today will explore the place of the law and institutions upholding the law when the past is erased or rearranged with malice. To borrow a phrase from Professor Pablo de Graef, the discussions that will follow will reflect on the future of the past. Now, I'm aware that it's a bit ironic to state that our panelists do not need an introduction and then to go on and introduce them, but I will keep the introductions brief, as you're all familiar with the impressive expertise that all of our panelists today bring to the table. Expanded biographies are, of course, available in our conference brochure, as well as our virtual platform, depending on whether you're following the conference in person or online. Now, after introducing the members of this panel, I would like to ask each of them for their one-line opening statement. Now, these one-line statements are a unique part of this year's panel format. The idea behind this, of course, is not to expect condensed answers on nuanced questions, but merely that they act as a springboard and allow for better audience engagement. And with these statements serving as a preview of what is to come, we can go on to deeper discussions and deliberations. So, if I could start, Professor Nadine Strossen is a chaired professor emerita at New York Law School, a senior fellow with the Foundation for Individual Rights and Expression, and a past national president of the American Civil Liberties Union. Professor Strossen.
Thank you so much, Kiran, and thank you so much to everybody here. As the daughter of a Holocaust survivor who barely survived the Buchenwald concentration camp, having been born in Berlin as a so-called half-Jew in 1922, I could not be more grateful to everybody here, including our gracious hosts, for the invaluable work you are doing to keep alive the memory and the horror of the Holocaust so that we can do everything possible to prevent such kinds of hatred and discrimination and killing and genocide in the future. I could not be more completely dedicated to those goals, but we are here to discuss also the most effective means, as well as the most principled means for advancing those goals. And on that ground, I have to say, not because of some kind of American exceptionalist, absolutist protection of free speech, but specifically from the perspective of what is the most effective way to counter anti-Semitism and other forms of hatred, of which I do believe Holocaust denial to be an example. I think the more effective way is not to outlaw it, but to counter it with the kinds of educational initiatives that so many of you are engaged in. And here I associate myself not just with American lawyers, but with human rights activists and Holocaust historians around the world, including the prominent Holocaust historians Deborah Lipstadt and Raoul Hilberg, who do and did, in Hilberg's case, strongly oppose laws criminalizing denial and distortion. Let me end by quoting the latest report, and actually the first report that was done by the United Nations and UNESCO on this topic, and I know we have many people from the United Nations here. It came out last year. It's called History Under Attack: Holocaust Denial and Distortion on Social Media. And I know that social media has been a particular concern, understandably. I was very heartened that this report throughout emphasizes information, education, media literacy. There's very, very little about suppressing, much less there's nothing about criminalizing Holocaust denial and distortion. And I'll end my long-winded one-liner by quoting just one key passage from this very excellent report. The biggest defense against the dangers of Holocaust denial and distortion is education about the history of the Holocaust within school curricula and education systems. Young people are also entitled to education that safeguards them against misinformation and disinformation, that explicitly teaches disciplinary frameworks and procedures of knowledge production. They further require the knowledge and social-emotional skills to identify and resist sharing Holocaust denial and distortion, and to respond appropriately should they encounter it. To this end, educators require training and support on the forms and functions of online hate speech and how to develop effective counter-messaging and strategies to overcome resistance to learning about the Holocaust. In other words, more speech, not less, will blaze the trail toward preventing another Holocaust. Thank you.
Thank you very much. Now, if I could move on to you, Ambassador Rapp. Ambassador Stephen Rapp is, I'm sure, familiar to this audience, but is senior fellow right now at the United States Holocaust Memorial Museum's Center for Prevention of Genocide. He previously served as the United States Ambassador at Large for Global Criminal Justice and as the prosecutor of the Special Court for Sierra Leone. Could I ask you for an opening statement?
Well, it's great to be here. I think maybe this is about the 15th or 16th time I've been in this courtroom, and it's always a moving thing to see the place where the project of international criminal justice began. a project that I was proud to serve in myself at the Rwanda Tribunal, prosecuting the media trial, and then later as the chief prosecutor of the Special Court for Sierra Leone, prosecuting President Charles Taylor of Liberia, and then for 6 years serving President Obama as ambassador at large for global criminal justice, coming here in 2010 with Sergei Lavrov, and from this spot here, together with Minister Vestervelli at the time, and French and British ministers opening the memoriam, which we'll see later this afternoon. I come, by the way, as you see from my tie, from Ukraine. My wife and life partner, Dolly Meyer, and I, Professor Meyer, traveled 26 hours by train from Kyiv in the last day and a half, and arrived late last night at 10:30. Wouldn't miss this for the world. Let me just say, in terms of, ask for that one line. The line is a little longer than one line, but it is indeed one sentence. It requires maybe just a little bit of explanation, which maybe we can get to in the question and answer period, though I may say a few words about it, following up on what Nadine has said. My one line is that the communication of genocide denial can be part of a course of conduct intended to and resulting in lawless violence, including the crime of genocide itself. And when it is, it should be investigated and vigorously prosecuted. Of course, here I'm talking about the sort of combination of speech and action. And it's the kind of thing we had, in a way, in the media trial, which I will discuss later. But I think, just coming from Ukraine, about an example of this, and that was what happened around the Holodomor, the genocide, which, according to a great historian who's studied it very carefully, the genocide by starvation of Ukrainians in 1932 and 1933 by the government of the Soviet Union, headed by Joseph Stalin, killed 3.5 million Ukrainians. It was denied at the time, intense campaign of disinformation, which was frankly adopted by Walter Duranty of the New York Times, who wrote disgraceful articles in the New York Times that essentially prevented and scrunched and crushed any sort of truth from coming out. And as a result, that genocide continued on into the summer of 1933, resulting in millions of additional deaths that might have saved had Western countries like the United States, that was then engaging with the Soviet Union, had pressed for humanitarian relief. So, genocide denial can be seen then as part of essentially a conspiracy to commit the crime of genocide. There are other examples and other crimes, I should note. I think of something that's been a civil case in the United States, and it doesn't involve genocide. It involves essentially a small but horrendous case of mass killing, and that was the killing of the school children in Sandy Hook, Connecticut. More than 24 of them were shot down several years ago. And we had a purveyor of hate at InfoWars, Alex Jones, purveying a knowing lie that it was all made up, that the children had not been killed. And their parents used the civil law, essentially the tort law, that there was essentially an intentional infliction of emotional distress there that enabled them to win, multiple hundreds of millions of judgment. Money judgment, of course, as yet uncollected from Jones, but hopefully collected in part. But even there, one could see the potential, given the fact that Jones used this to build his media empire, to build his support, to essentially raise, indeed, the hundreds of millions of dollars of personal wealth that they're trying to get at. He used these lies to do it. Essentially, he defrauded those individuals that he was communicating this falsehood to. So there, again, you see this opportunity to use the law when speech leads on and is part of a course of conduct.
Thank you very much for that. Our next panelist is, of course, also familiar to all of you. Professor Christoph Safferling is the director of the International Nuremberg Principles Academy and professor of criminal law procedure, international criminal law, and public international law at the Friedrich Alexander University of Erlangen, Nuremberg. Could I ask you for a one-line opening statement, if possible?
Yes, thank you. If I only say one line, it would certainly sort of not match my on the panel here. So if you allow me to make a little excursion here, because I was asked this morning several times, what about freedom of religion and this horrendous cross that is hanging above me, giving obviously more authority to the person who is sitting here. Maybe I can give you just a short story about that. There is a law in Bavaria that in every courtroom there has to be a cross. Usually it's a small wooden cross without a crucifix. This specific cross was brought into this room in the early 1960s by the then president of the Upper Regional Court, one Theodor Haut, for several reasons. I mean, you know, and you have the pictures in mind of this courtroom in 1945 and 46. It was different then. It was larger, and it was turned around a little. The judge's bench was over there, but nevertheless, the defendants were here. The witness box was here, interpreters over there, and so forth. And when this room was given back by the Allied authorities, by the American authorities, to the Bavarian judiciary, they decided to put this room back to its original size because, first of all, such a large room was not needed for an ordinary criminal court in Nuremberg. And the other reason, I have to admit, you can see it in the files, was that any resemblance of the Nuremberg trials was to be sort of abolished. So now we are back to its original room when this Palace of Justice was opened in 1916. So that was the original size the room had. And Theodor Haut, being in this Protestant Nuremberg, a very Catholic president, the Bavarian authorities from Munich like to send Catholic presidents to this Protestant Nuremberg place, but he was really a radical Catholic, you might say. He decided to put up that cross, which is definitely too big for such a room and not required by Bavarian law, for two reasons. Also, first, for one reason, he wanted to re-sanctify the room. You can see this in the files. He wanted to re-sanctify the room, and indeed for two reasons. First of all, because in this very room, also the Sondergericht, the special court in the National Socialist period, sat and handed down horrible death penalties. And in order to do good and re-sanctify the room for that experiences that this room had, the cross was hung up, but also for the injustice, according to his opinion, that had happened in 45-46 at the Nuremberg trial against the major Nazi war criminals, because he was of the opinion, as most of German lawyers at that time were, that that was a piece of injustice, Siegerjustiz, and a violation of the principle of non-retroactive active criminal offenses. Okay, so that's the explanation. But of course, we have the freedom of religion in our constitution. As we have, and now I come back to the actual topic, we have the freedom of speech in our constitution, the basic law. But nevertheless, in Germany, Holocaust and genocide denial is a criminal offense. But, thus says our constitutional court, there is no conflict with the freedom of speech in the basic law, our constitution, because this constitution is an immediate reaction and an answer to the National Socialist regime, so that the freedom of speech is to be interpreted with regard to this historic responsibility. So criminalizing genocide denial, Holocaust denial, does not conflict with the freedom of speech as it is to be understood under the German constitution. And where else could you sort of symbolize and put in the most basic values of a society were it not in the criminal code? So that's where it is. The genocide denial, Holocaust denial, our criminal code contains as being one of the basic values of society. and the Holocaust denial obviously is part of this basis of our German society. That was my 5-liner.
Thank you very much to all of you for very evocative opening statements, and I think very much laying the foundations for what is to follow. Professor Safferling, if we can stay in this courtroom for one moment, and if I could ask you something in extension to what you've been talking about, what do you think is the place or the power of the precedent for the conversations we're going to have in the next couple of days? When you think about the fact that genocide was not part of the Nuremberg Charter of Judgment, and we actually have individuals here who were part of the first processes where genocide did become criminalized in an international judgment.
Well, as is it's true that the crime of genocide was not part of the IMT statute of the crimes that were prosecuted here in 45 and 46, I think nevertheless the existence of the crime of genocide has a lot to do with what happened in this room for several reasons. The main agenda in this room was to criminalize aggressive war. I think that was pretty clear, the political will, in particular of the US-American prosecution team, but my friends and colleagues from the United States can correct me if I'm wrong here, that they had the inclination to put an end to war. And so we need criminal law as a symbol against aggressive wars. Of course, I mean, the sensation that took place in this room was also to have a trial at all, you know, to establish criminal law against political leaders, military leaders of a country, and hold them responsible as individuals. So this is obviously something that has been materialized in this room for the first time. And obviously this is also something that is carrying through also then the Genocide Convention, which was then later adopted in 48. So the crime of aggression was at the center of the discussion here. Crimes against humanity was as a concept also new to sort of the criminal law field. Under the crimes against humanity and the war crime concept, the concentration camps, the forced labor regime, and other mass killings were surmised and prosecuted. And as I also said yesterday in my opening remarks, for some reason that is maybe not totally clear, the actual amount of the killings and the systematized and industrialized killings as they took place in these death camps. It was said in this room, but nobody really seemed to believe. And we only had one witness really reporting on the life in a concentration camp, the tortures that took place in the concentration camp, the killings. And after that was a French resident fighter that was actually here being questioned. And after her testimony, the presiding judge said, "Dear prosecutor, I think we had enough of this concentration camps now. We know what it is and what it looks like. We don't need further witnesses on that." So that's an interesting thing. And I'm saying that because what outraged Raphael Lemkin when he read the judgment was exactly this, that genocide was actually not taken into account to a manner that would make him happy, make him content, is what he had expected. Had the trial sort of brought everything in a reasonable manner under the crime of aggression, I think Raphael Lemkin would have been happy, and maybe he would not have had felt the necessity to promote his idea of genocide to such extent as he did. He sacrificed his life for that. But because of that deficiency in the Nuremberg judgment, I think we have the crime of genocide, because Raphael Lemkin then managed to persuade enough states to bring forward that, as a new crime.
Thank you very much for that. If I could ask you, Professor Strossen, it's very intriguing to hear you say more speech, not less speech. Could you maybe tell us a bit more about that? And if you also apply that statement to the high threshold of genocide denial?
Yes, thank you, Kiran. And I'd like, in the spirit of having a discussion, I'd also love to respond to the learned comments of my esteemed co-panelists, starting with Christoph Safferling's recounting of how, I don't know, the unwillingness to grasp the enormity of what the Nazis had done for such a long time. And I think in part that was due to Holocaust survivors' understandable reluctance to talk about their experiences. That was certainly true for my father. Only at the very end of his life did he begin to talk about what he had experienced. And if I may, I pulled this out when you were talking. Somebody sent me, it was the mother of an American service member who had liberated the Buchenwald camp where my father was imprisoned, and years ago she sent me an old newspaper article from 1946. My father had never told me about this. When he was liberated and came to the United States, he visited her son, and the local newspaper interviewed him as a war hero because he had worked with the Americans to try to track down Nazis. And it was I read more from my father than I ever heard in this interview from 1946 than I had ever heard him say in life. And here's one thing he said. This was December 1946. And he's talking to the newspaper reporter, and he says, "One thing I would like you to say is this. I have seen the publicity in newspapers and movies on what the concentration camps were like. No picture or novel could possibly give the full picture of the cruelty of the Nazis. Only the minor things have been publicized. If the bad things would have been shown, people could not have stood to have seen them. I pray with all my heart that it will never be permitted to happen again." So again, you see my depth of gratitude here and my complete commitment to doing whatever is necessary, and that includes whatever is effective. I completely agree with Stephen that and here I'm talking about not only the principles of First Amendment law, but also the principles of international human rights law, in particular the International Covenant Against Civil and Political, for Civil and Political Rights, Articles 19 and 20, and the Convention for the Elimination of Racial Discrimination, Article 4, both of which have been interpreted, I think, very similarly to First Amendment law and very similar to the point that, in accordance with the point that Stephen made, which is when you get beyond the loathsome and loathed content of the speech, which should not alone be enough to suppress it, but you look at it in its overall context, if in the context it poses an emergency or directly or imminently causes or threatens certain specific harm, then it can and should be punished. And it has been appropriately under American law, as well as international law. Stephen gave one example. Another example that I was thinking of that relates to hateful, racist speech is the loathsome speech of the Unite the Right demonstrators in Charlottesville. Many of you will have read about this in August of 2017. They were marching. It clearly had Nazi-type resonances. They were marching in uniforms, brandishing lighted tiki torches, and chanting, "You will not replace us. Jews will not replace us." That expression alone is not punishable, I think, under the applicable legal principles. But you look at it in the context. They were marching toward counter-demonstrators who were demonstrating against their hatred, against their violence, and approached the counter-demonstrators at menacingly close distance, brandishing these tiki torches in their faces. That is a punishable true threat. And part of the disaster in Charlottesville, as was attested to by a nonpartisan commission after the fact, was that law enforcement was not there to arrest people who were engaging in assault as well as unprotected expression. And obviously during the Weimar Republic, there was a lot of failure to punish. There was a lot of punishment of speech, but not enough of actual violence and actual assault. Another example coming out of Charlottesville, Stephen, very similar to the Jones case, which I agree was completely appropriate. There was a conspiracy trial that was brought against the organization and individuals who masterminded the plans for carrying out violence there. And their speech was part of a conspiracy to commit actual violence and was appropriately punished. I think in terms of Christoph's points about the German law, I think it's really important for all of us not to get hung up on legal technicalities, important as the rule of law is. There's a lot of room for interpretation under the laws of the United Nations treaties, American law, European law, including German law. And I have to acknowledge that there are a lot of people in the United States who think that we should go in the direction of where German law is, who say, especially among younger generations, that we should punish speech solely because it conveys a detested idea. Believe me, in the last 10 days, there has been enormous pressure to punish anti-Semitic, anti-Israeli speech that is proliferating around the United States, including on college campuses. Now, I don't hear a call to imprison students who are issuing pro-Hamas statements, but there are calls for very severe sanctions from a practical perspective. There's a lot of advocacy and some action in saying any student who has even signed a petition or even joined an organization that signed a petition that is celebrating Hamas terrorism should not be employable, should not, no firm should ever, no company should ever hire any of these students. So these are, and there's a lot of support for that now in my country. Conversely, I know in Germany and other European countries, there's a lot of support, there's a lot of opposition to punishing that kind of speech and moving more in the direction of the American law. I quote a couple. I wrote a book a few years ago, which this could have been actually should have been my one-liner. Hate, why we should resist it with free speech, not censorship. So that is the bottom line. And one of the many Germans that I quote here is Anna Sauerbrei, editor of Der Tagesspiegel. She says, the American way of dealing with Nazism always seemed to me the more mature way of handling threats to liberal democracy. Germany's outlawing of hate speech seems like a permanent declaration of distrust in argument and education. I have faith in a democratic public's ability to police itself. I wish Germany did. So in a way, I've come full circle, I think, to answering your question, Kiran.
Thank you very much, and I'm sure we'll pick up on some very interesting points that you've made. Ambassador Rapp, I'm sure you'd want to respond to that, but I was also wondering, considering your very unique expertise with the media trial that you brought up, whether you could also reflect a little bit on how that decision can be reconciled with an entirely changed media landscape today.
Well, thank you for the question, and let me sort of put it in context if I can. And of course, when you talk about the media trial, we have to recognize the president of the Nuremberg Principals Academy, Navi Pillay, who was the presiding judge in the media trial and who introduced me to international law. I was the third lead prosecutor, and she said, well, how are you going to do, Mr. Rapp? And I said, perhaps third time will be the charm. And we did eventually succeed after 27 months. in proving a case that the judges found for incitement, direct and public incitement to genocide, for conspiracy to commit genocide, for genocide having itself been committed because and through the hate speech, and for another crime, a crime that was actually prosecuted here at Nuremberg, the crime against humanity of persecution, that speech that actually instigates violence on a racial, ethnic, and indeed it's broader than in genocide. It also includes a political group. We also obtain convictions for persecution via the hate speech, which is an extremely important principle because a lot of the genocide conspiracy, frankly, involved destroying the moderate Hutu community, the first people to die. All of the ministers murdered on the morning of April 7th were Hutu except one. And they were people that would have protected the Tutsis. And they'd been attacked in the media for months beforehand as essentially traitors to their group. And in a sense, you could maybe relate that to the incitement against the Tutsis, but it was really, to some extent, more of a political crime against humanity, persecution of a group on a political basis. But it was here at Nuremberg that we actually had prosecutions for those crimes, and involving two of the accused. We had on one hand up here on the far right-hand corner, we don't see him, but maybe we'll see him in that sort of virtual image of the courtroom that I hope people will have a chance to see the projection of, Hans Fritzsche, who'd been the number 3 in the propaganda ministry under Goebbels. Of course, he committed suicide. Probably should have prosecuted the number 2, but he got away, and so they prosecuted number 3. And Hans Fritzsche had a program all during the war on German radio called Hans Fritzsche Speaks. And he would, of course, constantly be maximizing the Nazi victories and minimizing the Allied ones. At one point, he said, for instance, that the fate of the Jews had been every bit as serious as the Fuhrer had predicted. Of course, not necessarily calling for the completion of the Holocaust. Hans Fritzsche was acquitted here of crimes against humanity, persecution. On the other hand, and to some extent more controversial, Julius Streicher, who had been since 1923 the editor of Der Stürmer, that had been hateful for a generation, and it could be said had poisoned the minds of the German people against the Jews in a country that had not been particularly anti-Semitic compared to countries further east, to be frank. He had sort of laid the groundwork for it. He had, of course, risen to be Gauleiter of Franconia here. The Nazis at one point even had him under house arrest because they thought he was a little bit too much of an extremist, so the Fuhrer really liked him. But the most direct and nasty thing that he said was in Der Stürmer in May of 1939. He says, we need to launch an expeditionary force into Soviet Russia and destroy the Jewish people root and branch. And basically for that communication, he's found guilty of a persecution as a crime against humanity. And he's the only one who, by the way, when he was hanged out back in October of 1946, gave the Hitler salute on the gallows. There was controversy about that. I mean, Biddle, the American judge, said at one time, he's repulsive, but is being repulsive enough to convict someone. But it certainly suggested to us that this sort of communication that was made by somebody like him, and keep in mind he was not involved in the Nazi hierarchy. He was not charged for the crime of crimes, the crime of aggression. He was only charged under count 4, crimes against humanity, for the communications, not involved in orders at all. So he was, in a sense, an instigator, a direct form of perpetration of this crime. And sort of the question that we have, those of us that, frankly, do want to relate the speech to the conduct, is the sort of immediacy and the imminence. And some have been critical of that particular decision, saying a communication in May of 1939, and then it's not until June of 41 that Russia's invaded. And not until a few months later, beginning at Babi Yar, where Dolly and I just were 2 days ago, in September of 1941, that they begin the executions, the final solution by gun. that eventually is the Einsatzgruppen that Ben Ferenc prosecutes here, our good friend who died in April at the age of 103 and was often a visitor here, of course, began his legal career here at the age of 27, opening the subsequent case of the Einsatzgruppen, which we'll see memorialized upstairs as well, the greatest murder trial in history. But that was all seen as a result of that Streicher communication and that hatred. And it certainly argues to me that in terms of immediacy and imminence, as Navi said in the trial chamber in Akiyesu, we have to look at the context. We have to look at the reality, the situation, the society, what's occurring. We have to look at what can be potentially really an intentional course of conduct to sort of prepare a people to not just hate their neighbor, but to kill their neighbor. And so it is important, I think, that we, in every one of these situations, bring in that context and understand that there's a difference in what you have. I mean, I'm reminded in terms of the American difference between our attitude on free speech and sometimes the European attitude. We have this hateful guy in Nebraska, Gary Lauk, who publishes all of these newsletters that he sends to neo-Nazi groups in Eastern Europe that is full of lies and denial, but at the same time he's denying it. He said, we didn't commit a genocide, but now we need to finish it. That's his kind of message. And his communications from Nebraska, USA, are frankly protected by the US First Amendment. On the other hand, when he showed up in Denmark a few years ago, he was extradited to Germany and prosecuted and sent to jail for 4 years. And then more recently, he's had his communications up on the internet, and there have been efforts to take it down in Europe and elsewhere. So there is a difference. On the other hand, there's people in Nebraska aren't committing genocide. There isn't the context. And so I think we always have to look at the context. In regard, and I should say something else about the Holocaust in this courtroom, just in deference to the team, and I fully recognize that the Americans were enormously motivated by the crime of crimes, and the crimes against peace, both the major crime against peace, waging an aggressive war, and the conspiracy to wage an aggressive war, counts 1 and 2 of the indictment. And as the judges said here on September 30th, 1946, that this crime of aggression, these crimes against peace, incorporated evil of the whole. And obviously the war crimes and other things, indeed the full Holocaust would not have taken place but for the war. But there was some presentation of the concentration camps, particularly in the films. My good friend Sandra Schulberg, who many of you know because her famous father, Stuart Schulberg, who was an advisor to the prosecution, Bud Schulberg, the more famous of them, who won an Oscar for On the Waterfront screenplay, and who lived until just a few years ago. His father, Stuart, died just in the early 1950s. But anyway, Bud and Stuart were involved in finding the films that the Nazis had. And she has a new film out that's just wonderful, and I hope it's showing up now at film festivals, called Filmmakers for the Prosecution. And they describe their intense efforts to gather the Nazi films together and failing constantly, because as soon as they arrived, Nazi sympathizers would be lighting those, silver nitrate, negatives, and they'd be exploding and they wouldn't get them. But they went to Babelsberg in Berlin, which has been the Hollywood of Germany, and with cooperation of the Russians, actually got the films. And so they were able here to finally, they put on 2 films, one, The Nazi Plan, which was more common films about Munich and the Rhineland and Czechoslovakia and Poland, etc., about the aggressive war. But then they also put on one called the concentration camps. And that was really dramatic. And as I say, that presentation occurred. And I should note that also, eventually as a defense witness, one of the prosecutors, Whitney Harris, tells this story before he died about 10 years ago, that there was a defense witness who appeared here for Kaltenbrunner, and that was, Rudolf Franz Ferdinand Höss, who in fact was asked as a defense witness, did Kaltenbrunner ever go to Auschwitz? And he said, no, Kaltenbrunner never went to Auschwitz. He said, what'd you do at Auschwitz? Well, we killed 2.5 to 3 million people, And we got 400,000 Jews in the summer of 1944 alone. Now, frankly, he exaggerated the number dead, though he was quite accurate about the number killed in Auschwitz. So there was testimony here about it. I'll talk further about the media trial, but I just wanted to note that these facts did come out in this courtroom, though without the sort of human testimony that we saw in the Eichmann trial and in other proceedings.
Thank you very much, and we'll definitely come back to the media trial. But Professor Safferling, you've heard about the various views on the German approach or experience towards denial legislation. Could you maybe tell us a bit about your views?
You know, the interesting question, now is, you rightly said that numbers were given on the Holocaust, but the question now is if after 1946, after the handing down of the judgment and after that evaluation of these, numbers by this IMT, what do you do with someone who said, no, it didn't happen? This didn't happen. This is fake news, alternative facts. What do you do with someone like that? And indeed, Germany, and not from the very beginning onwards, I dare say, okay, not from 1949 onwards, the criminal code had a criminalization of the Holocaust denial. It was only introduced in the 60s, okay? The norm 130 of the criminal code was existent even before, of course, but maybe that our criminal code is from 1871, shortly after the Gründung des Reiches under Emperor Wilhelm. We passed so many of our laws which are still applicable today, and amongst them is the criminal code. And at that time, the norm was actually meant to address class struggle, incitement to class struggle, as you would expect in the late 19th century. That was the criminal offense. And only in the 1960s, it was then amended or sort of modified, and it still has the heading incitement of masses, Volksverhetzung, incitement of masses. So it's not totally loose from, as Stephen has said, what the violence that might be encouraged by the Holocaust denial. It's connected to that. You can see that by the heading. It's incitement to masses. But you can incite and you can call for violence by denying what happened or by trivializing, downplaying what happened in the concentration camps in Auschwitz and the death camps elsewhere. So that's the general idea, that by denying, you actually encourage people. And obviously you have to make public statements and statements that are apt sort of to actually do this, sort of have this inciting certain effect. But there is also another reason why we have a criminal offense for the Holocaust denial, and that's the dignity of the victims. Because we think that it is actually an insult for all those 6 million and more that have been killed by the Nazis if you distort the facts. So it's both. It's the incitement, we call it the disturbance of public peace. So there's a threat of being incited, encouraged to, prone to violence again. But at the same time also, you deny dignity of those who have been killed. So this is the reason for this criminal norm. I'm not talking about the European context here. We've seen modifications now, but I'm talking about the German context. And as I said, that was implemented in the 1960s, and it took some time before sort of also the judiciary came to terms with it. And indeed, they had a very narrow approach at the beginning, and now they have a little bit of a more of a wider approach. Of course, even as we see today, anti-Semitic speech and hate speech and resemblance to National Socialism is sort of recurring. It's getting stronger, it seems. So the norm also becomes more important. And Nadine, I really like your quote from obviously a German journalist, if I understood you correctly, saying that the US approach to give freedom of speech the prevalence is a more mature response to those kind of attacks on human dignity and the disturbance of the public peace and so forth, and that Germans should trust more in democracy. Now, you know that next year we celebrate 75 years of actually the adoption of our constitution, of our basic law, and I think there will be a lot of writing and thinking about how much do we trust our democracy. And how much can Germans be trusted with democracy? And maybe indeed that is the reason, because we as a society and the representatives at the parliament had the impression, and the fathers and mothers of the basic law had the impression, that we are not mature enough, that we have to be a little bit more cautious about freedom of speech, because democracy is maybe not so much in our DNA as it is maybe in the United States. That might have changed over the last 75 years, but that's still to be discussed. And I know, of course, that's my final sentence, Kiran, that democracy in Germany is older than 1949. We have had much more experiences also with parliamentarism, even during the emperorship after the Reichsgründung in 1871. We did have elections, we did have a strong parliament, and Germany introduced a right to election for women at quite an early stage, for example. Also the Weimar Republic, there is a democratic history, but nevertheless, of course, we had this disaster for these 12 years, 1,000 years it was supposed to last. So we have to be a little bit more cautious, maybe.
I think that I keep thinking of Winston Churchill's famous aphorism that democracy is the worst form of government except for all the others. And I also believe that freedom of speech is incredibly dangerous, but to me, it's less dangerous than censorship. It's really a comparison of what is the lesser of the evils here. And one of the things that, since Stephen talked so eloquently about Julius Streicher, he was tried many, many times under the old laws that Christoph referred to. There were multiple laws against insult, and although they did not explicitly refer to Jews, they were interpreted as protecting Jews. And I've read the records of the central organization that represented Jews. Please, my father did not want me to learn German, as you can understand, so forgive my atrocious pronunciation, but the Zentralverein. And they had offices all over the country and were goading and had good relations with prosecutors, goading them to bring prosecutions against anti-Semites for their inflammatory speech. And Streicher was brought to court dozens of times, and Nazi pamphlets were confiscated and publications were suppressed. Hitler himself wasn't allowed to speak for 2 years. And, the Nazis used this as propaganda platforms. Here's an excerpt from one of the historians who studied this, Calvin College professor Randall Beitwerk. Streicher and Holtz, his co-worker, addressed the court. They're talking about in the Weimar Republic, one of these prosecutions for insulting Jews, as if it were a mass meeting, which is indeed how he probably viewed it. The courtroom was a platform from which they could reach an enormous audience. A jail term was a fruitful well of propaganda. Since his followers were convinced of his innocence, trials became evidence of his persecution. Ironically, the more Streicher was brought to court, the more highly his followers thought of him. To the Nazis, the benefits of a trial more than outweighed the costs. So I think, I'm just asking, more appropriately, the international law and domestic law as well ask for a cost-benefit balancing. We shouldn't assume that the censorship or the punishment of speech is going to be to suppress the message. Ironically, it might well amplify the message.
Thank you very much. I have to note that in around 3 minutes or so, we'd like to start taking questions, both from the audience, but if you're online, please send us your questions. I'm sure our panelists will appreciate it. Ambassador Rapp, I was wondering if you'd like to respond to our conversation so far.
Well, let me just start by saying, you know, as a prosecutor, and I only came to prosecution when I was appointed a U.S. attorney in '93. I'd been a defense attorney before that, and even though in the American system and common law system, the prosecutors representing the state, they called us the government, you know, when we were prosecuting, I always thought that my role was the representative of the victims, the survivors, and thought that if I wasn't in the same place as they were, I was probably in the wrong place. And seeing people like a representative of the mothers of Srebrenica and others, this whole question, you know, troubles me because I know how painful these attacks are. I've been to Srebrenica for many of the commemorations and seen the signs of denial above the very graveyard, where now some 7,000 remains of the Menon boys that were murdered as a genocide at Srebrenica are interred and honored. And here you have these messages of denial, and I know how painful that is. As I'm less of an absolutist than Nadine on these questions and want to look then for avenues. But I am much more comfortable in the law, in terms of the criminal law, being used as something that focuses on conduct. And there are lots of ways in which I think to some extent we see that going after other things, belief, for instance, or speech, as leading us astray and creating tools in the hands of those that would actually want to destroy our democratic freedoms and our individual freedoms. And I mean, we see it even in the terrorism context, where people are called terrorists, not because they did something, but because they're part of an organization. Now, what did they do? Well, they don't have proof of that, so they're just going to convict them as a member of the organization. Sometimes that's the only tool, and the sentencing may reflect something about their conduct. But, you know, you have these cases in Iraq where everybody who's an ISIS member is sort of automatically convicted and sentenced to death. That allows them to be martyrs and to be seen as martyrs to a pure form of the religion, rather than someone that went out and raped and murdered little Yazidi girls, etc., committed acts of bestial cruelty, really for their own avaricious desires, to be frank, not for any religion. And so you really want to deal with that conduct and to prove it. And sometimes that's very difficult. We have a very difficult time getting inside criminal organizations and figuring out what was really going on. So we know the challenges. But I mean, we see how now anyone who takes a particular position, sometimes in countries, if there's an incitement law, they'll say, well, you're inciting hatred of the government. In other words, opposing the dictator. We're going to lock you up. You belong to an organization that is associated with Western ideas. Therefore, we're going to lock you up because of that association. We're going to deny the license, close your paper, et cetera, attack the journalists, et cetera. And all of these things can be misused. So I want to see very realistically us being able to look at those examples of false statements and see how they relate to a campaign of hatred and destruction. I mean, just in Ukraine we had a great panel. It was actually the Syrian-Ukrainian network. We brought many Syrian survivors to Ukraine in solidarity and talking about similar experiences. We had 2 big panels on disinformation. And frankly, you can see in the context of what Putin and the Russians have done, very much a plan which is outlined in frankly, Timothy Snyder's book, Road to Unfreedom, which describes how disinformation played a role in constant denial of reality and truth, et cetera, turning essentially things on its head, actually played a role in enabling other crimes. And when we there have Lithuanian and Estonian representatives who said the smartest thing we did was ban RT, Russia Today, because it was full of this propaganda that was going to try to incite Russian speakers against our democratic government, et cetera. Well, if you can show that that was the purpose of it, and they were doing it, then potentially you've got a case. But I want to see that proof of that larger plan, and I want to see that involvement, because I think without that, we have a cure that becomes worse than the disease, and we essentially kill the antibodies, a key part of which is free expression, for suppressing this temper. And when I say it's not a disease, that, like sometimes when people look at a genocide, they say, oh, it's like a natural disaster. Or they say ethnic killing broke out. It's like, no, 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 never. I mean, that's the worst line I ever hear from the defense is they were crazy people out of control. We couldn't do anything with them. They were out there killing people for 100 days, hacking them to death, and we were afraid of them. Insane. That is not the way the world operates. Mobs exist for a few hours and they do horrible things. But to continue a plan like this, you need to resupply, you need to provide the arms, you need to provide the fuel, you need to provide the hate to people that didn't know it in the first place, or people that weren't trained in the first place. And you need to finish the job like the Rwandan government decided in its Act for the Self-Defense in late May of 1994. Finish the genocide, bring the Interahamwe under control, and make sure they kill the rest of the Tutsis and not others. And so, you actually see that there is a plan. Finding the evidence of that, the true evidence of it, is enormously challenging. But that's what we need to do. And then rely on the criminal law and its burden of imminent conviction or beyond a reasonable doubt to protect the innocent.
Thank you very much. Great note, I think, to start taking questions from the audience. If you have questions, please raise your hand. And you see there are microphones on the back. So, yeah, you may go and, yes. Or the other side, next to you.
Hi. I have a question for Ambassador Rapp. My name is Emil. I come here from Srebrenica together with Manira. And I have a question for you regarding because you prosecuted the media trial at the ICTR. Now my question for you is really, would you consider it a failure on the part of the ICTY that the Serbian media were never prosecuted? And the reason I'm asking is not to bash anybody here or to criticize, it's just that I need to tell you a little bit about what we are left with, the consequences of that. And one of the consequences is that, for instance, Ratko Mladic is perfectly capable of calling in from his detention in Scheveningen into a morning show on a TV station with national frequency and taking part in a political debate. Or, more recently, a certain Vinko Pandurevic, who himself was actually found guilty for crimes against humanity and complicity in genocide, is invited, and all of these Serbian war criminals, but he's actually one of the more prominent, are invited to Serbian TV stations with national frequencies I'm talking about here. So everybody in Serbia can see them, and some of us in Bosnia can also see them, to provide advice and opinion on, let's say, conflict in Israel-Palestine. So, and that's what we're left with. These guys are now, have been completely legitimated by the very media that, as you said yourself very aptly just a few moments ago, maintained and provided the hate, not for 100 days, but for 3.5 years. So is there a reason that media could have been prosecuted in Rwanda and couldn't be prosecuted in Europe? Because obviously, as you know, media was part and parcel and is part and parcel, and we see that in Ukraine, we see that media is always part and parcel of any mass atrocity violence. So I would really like your opinion on whether it was a failure not to prosecute at ICTY, and what do you think are the reasons for that? Thank you.
Thank you very much. Maybe before we respond, we can take more questions. If you could introduce yourself briefly as well.
My name is David Kay. I teach law at the University of California, Irvine. I was the UN Special Rapporteur on Freedom of Expression for 6 years. And my question goes to the de jure part of the panel's title. I think I have a sense, certainly where Professor Strossen stands on this question, but I want to make sure I understand where all the panelists fall on this question of whether denialism on its own, because many of the national laws don't by their terms reference incitement or consequence, but whether denialism of genocide, any genocide, is lawful, whether we're talking about Article 10 of the European Convention on Human Rights or Article 19, Article 20 of the ICCPR. I'm not sure I've heard exactly where everybody stands, and I'd be interested to know, first, whether you think that denialism laws are lawful, and if so, what are the standards that we should be grappling with to ensure that, that they meet standards of international human rights law? Thank you.
Thank you very much. That's a great question, and I was wondering maybe we can ask everyone to briefly reflect on that before we go to the more specific question that was asked by our first person. So would you like to start, perhaps, Professor Strossen, very briefly?
Yes, well, David Kay has been such an effective and influential spokesperson for a robust speech protective interpretation of the international human rights speech standards, but he's following in a tradition and trajectory among United Nations bodies and officials, I would say in the past at least 10 years, of ensuring that even the mandate in Article 20 of the ICCPR to outlaw incitement to genocide be interpreted with consistent with the very appropriately speech protective rigorous standards of Article 19, that not the idea alone is sufficient to punish it, but considered in context that it causes material harm and that reducing the speech or suppressing the speech will reduce the harm and is the least restrictive alternative that will appropriately do so, that the standards for doing it are narrowly tailored. To me, that very much overlaps with American law and common sense, even more importantly, right? It's one thing to restrict speech if it will gain us some benefit, and certainly reducing the likelihood or potential of genocide is an incalculable benefit. But why should we reduce speech if it's not going to have that benefit, or worse yet, might even be counterproductive in turning these people into martyrs and, you know, the forbidden fruits phenomenon. I was very heartened in this UNESCO report that I cited about Holocaust denialism that it, in talking about content moderation, does invoke the Rabat Plan of Action from the United Nations, which, consistent with David Kay's work when he was a special rapporteur on freedom of expression, does insist that the speech restriction, including of denialism, could only be done as the last resort if every other option for reducing the dangerous ideas, in this case denialism and distortion, if every other step has failed.
Thank you very much, Professor Safferling.
Thank you, David, for this question. In case you were really doubting what my stand in that question is, may I read out the norm that I like to refer to according to the German Criminal Code so that you know what I'm actually referring to. And this is section 130, paragraph 4. And it says, whoever publicly or in a meeting disturbs the public peace in a manner which violates the dignity of the victims by approving of, glorifying or justifying National Socialist tyranny and arbitrary rule incurs a penalty of imprisonment for a term not exceeding 3 years or a fine. Okay? So that's the simple, the ordinary Auschwitz lie, as we call it. The basis, you know, the most lenient form of punishment, and there are more qualified forms to follow if you then indeed do this in a manner which disturbs the public peace. But that's the ground line. And I think that in particular for Germany, and looking at our history, it's good that we have this norm. Me personally, you know, I really can sleep better because of this norm, I have to admit. And it's not only that we can then prosecute people who contradict. It also brings us in a position to, for example, disallow assemblies of neo-Nazis because there is the danger of them committing those kind of crimes. You had these annual celebrations of Rudolf Hess who has a grave in Wunsiedel, not far from here, south of Bavaria, in south of Germany. And every year you had these assemblies of neo-Nazis celebrating Rudolf Hess, the number 2 in the party after Adolf Hitler. And now these mass assemblies could be disallowed because we have this norm. And this is actually also the case because of which then the Constitutional Court approved of this criminal offense, saying that indeed because, as I said in my initial statement, our Constitution is a reaction to National Socialism. Given our history, we can limit sort of freedom of expression, freedom of speech, and that a way that we criminalize Holocaust denial. I think for Germany, at least, that's the right way to go forward.
To say something about that example, because, and this is something I quoted in my book, I guess while the demonstration was still allowed to take place, there was an article in the New York Times that described how some anti-Nazi Germans had turned that annual march into an involuntary walkathon. So to me, you know, this is a wonderful counter-speech example that might well be more effective than just banning the march. For every meter the neo-Nazis marched, local residents and businesses pledged to donate 10 euros to a program that helps people leave right-wing extremist groups. They turned the march into a mock sporting event. Someone stenciled onto the street, "Start," and a finish line as if it were a race. A sign at the end of the route thanked the marchers for their contribution to the anti-Nazi cause, 10,000 euros.
Yeah, let me make clear where I think the law is. First of all, in the United States of America, under our First Amendment to the Constitution, a law criminalizing genocide denial, full stop, without any consideration of other conduct, would be struck down by our Supreme Court by a vote of 9-0. The same way they struck down the St. Paul, Minnesota, anti-cross-burning law. They don't agree on anything. In the Supreme Court, almost anything, but they would agree on this. It would be impossible. Internationally, however, I mean, we've got the First Amendment of the United States. Congress shall make no law restricting the freedom of the speech, or and other freedom of the press, assembly, etc. Very definitive. And so internationally, though, as David points out, and others, we have the International Covenant, which comes to us to implement the Universal Declaration of Human Rights, which we'll commemorate the anniversary of in 6 weeks, 75th anniversary. There, you have an Article 19 on free expression, and then you've got this Article 20 that actually mandates that states, as part of their human rights responsibilities, restrict speech which causes violence, discrimination, etc. Even goes beyond violence, even to discrimination. And I think, and as we dealt with in the media trial, even though I wanted very much to, and I think we would have convicted our defendants in the United States because of the conduct relationship, our case, by the way, was heavily criticized. Open Society filed a brief against us on appeal, written by my person I later appointed as my first deputy, Professor Diane Orenlicker. They thought our decision was dangerous, to be frank. And to some extent, I think if you read the entire trial chamber decision, you see that there's an understanding that we're implementing international law. And given the law of nations, entirely, and given Article 20, it is possible to restrict speech like this. Frankly, I think that under Article 20, genocide denial laws can be upheld. Now, I'm not frankly comfortable with that as an American, and I want to get these things together. But I don't think that anyone taking a case to Strasbourg, for instance, against any of these laws would be successful.
If I could, Stephen, I wanted to, I've adverted to it, but I want to quote it. General Comment 34 from the Human Rights Committee, which has authority to monitor implementation of Articles 19 and 20, in paragraph, and this is from 2011. It's a point that's been reaffirmed since then by other UN bodies and officials. In paragraph 49, laws that penalize the expression of opinions about historical facts are incompatible with the obligations that the covenant imposes on state parties. The covenant does not permit general prohibition of expressions of an erroneous opinion or an incorrect interpretation of past events. And likewise, in General Recommendation 35 by the ICERD with respect to Article 4 of the Convention to Eliminate Racial Discrimination, quotes this paragraph, this came out in 2013, the expression of opinions about historical facts should not be prohibited or punished. So the UN law, in contrast with the German law and the European Court of Human Rights, does absolutely prohibit the criminalization of merely incorrect facts or opinions.
Well, as I said before, the German criminal code connects it to either the public incitement or the violation of the dignity of the victim. So there is always a connection to some third sort of instant, rather than the mere expression of an opinion. And the other thing, I mean, it really makes me think, Nadine, you know, we've been quoting that the German public maybe can cope with it by having anti-demonstrations against neo-Nazis, and indeed that happens. There's a great share of people who stand up and have a festival against hate and so forth while a right-wing demonstration is underway. However, this is a really recent development. In the last 3-4 years, I think we can see that people are encouraged by that kind of demonstrations, by celebrating Rudolf Hess, are encouraged and take also anti-Semitic speech as being allowed again, being, no offense, being bearable in a way. So I see, and this is a very recent development in Germany. We have a right-wing party that is now in many I think even all of our federal parliaments and also in the Bundestag, and this speech is shifting. And this is what I'm a little bit afraid of. And you know how I speak when I say I'm afraid of. You say, well, trust in the democracy, right?
I'm afraid also, and how would you account for the rise of the AfD despite the enforcement of strict laws against racist speech?
Yes. I think, and this might also be different in the United States compared to Germany or to Europe even, criminal law is sort of the backbone of our moral sort of behavior. And so everything that is in the criminal code, or put it the other way around, if we think moral behavior is right or wrong, we put it into the criminal law. So that's the Decalogue, so to speak, the 10 Commandments, not being in a position as a pluralist society to relate on religion or tradition, whatever. We have the criminal code. And that has also been developing over the last, let's say, 10, 15 years more than before, when we had other sort of common denominators, glues for the society. Now criminal law is more than just criminalizing and prosecuting and punishing. It's also symbolic. So that's another sort of effect that the criminal law has.
Thank you very much. Are there any more questions?
I did want to answer the question of the gentleman regarding Srebrenica and Bosnia and Serbian media. And first of all, as a prosecutor, I know it's always challenging to deal with things that are out there and having to prove them, and there's so many horrible things that happen in so many places where you don't have the proof of individual criminal responsibility, that it's really unfair to come back and say to a prosecutor in a challenging situation that's one like my colleagues at the ICTY, represented here by the current prosecutor of the IRMCT, Serge Brammertz, to say you won 80% of your cases, you should have won more. There were situations that you could have dealt with and that you didn't. Do keep in mind that the ICTY did prosecute Sechel. It was a very challenging case that ran into some judicial management issues, to be frank, and did in the end result in at least a conviction regarding incitement that was actually committed within Serbia. and Vojvodina area. Not an adequate conviction by any means, and we know of Sechel's continued negative role. Obviously, and I often consulted with my Yugoslavia colleagues. We were sister tribunals in my decade there, in the first decade of this century, on the commonalities and ways that this could be approached. But the most operative law and the most useful law when it comes to restricting or criminalizing speech in the context of genocide isn't direct and public incitement to genocide. And there you have to, it's possible to convict someone, as we did in several cases at the ICTR, for giving the speech without proving that it had the effect. It's an inchoate crime. You didn't have to prove that that caused the death of a single person, only that it was in a context where there was that great threat, and that was clarified in our media judgment. So, context in Nebraska is different than the context in Rwanda in April of 1994. So you look at that context and say that speech, even though we can't show it caused anything. That's very useful. But we know the challenge that the prosecutor had at the Yugoslavia Tribunal in winning genocide beyond Srebrenica. Something that's criticized even by our good friend Bill Shavis, is saying that's not a genocide, that's only 8,000, that's only one valley along the Drina that this happened, that's not a genocide. The prosecutor has tried time and time again to win genocide convictions for other conduct throughout Bosnia, in the townships, as we say, and has failed. The judges have refused to accept that. So we didn't really have that tool, and you would have to go back to persecution as a crime against humanity, where you have to show persecution is not an inchoate crime. You have to show the direct connection to specific violence. So it is a much more difficult context to accomplish it. I do note, however, that this business of, one, prison authorities, once somebody is in prison, don't have to allow people to continue to have access. There is a restriction of freedom on people, and people in prison continuing to be involved in talk-in shows and to spread the hate is something, their rights can be restricted, and I don't understand that happens. Secondly, there's been a profound failure by the judges, particularly at the Yugoslavia and Rwanda Tribunal, under particularly, my good friend Ted Menon when he was president, to let people out after 2/3 of their sentence without any showing of contrition, without any program of probation, without any assistance to the process of justice and reconciliation in the region. My colleagues at the Sierra Leone court, by contrast, have a plan for people to be released early. It involves that. It involves not participating in politics, not exacerbating the violence which you were convicted of in the first place, and have in one case provisionally revoked someone who was released and brought them back in for 10 months and then released them under the assurance that that was going to happen. That tool should have been used. The judges in their plenary have refused to adopt the Sierra Leone model, and that I think is unfortunate. That permits these people that do get out, as they did until Meron's term ended, after 2/3 with no conditions, it would permit some restriction on these people who come back and play the hero and continue to, in fact, pick away at the scab, so to speak, and see if they can get the bleeding going again.
I would want to take a question from our online audience, but also there was one question from the back. I think we have time for one question. We do. But we can also take your question. And then I would then ask everyone to provide, brief and provide a closing statement, so as to speak.
No, the quick question I had, we speak about genocide denial, freedom of speech. Of course, we will not leave this room with a joint opinion over the issue. But in Belgium, we had 5 years ago, I think in 19, legislation on genocide denial. And the big debate in Parliament was, what is genocide denial? And the criteria which was decided was, well, genocide and crimes against humanity and war crimes which denial is punishable are those which have been recognized in a final decision by an international tribunal, where at the same time in Parliament there was a debate about the Armenian genocide and other genocides which are politically accepted by a number of parliaments as being genocide, but which have not been recognized by an international tribunal for lack of jurisdiction or whatever. So my question to the panelists is, so where I'm coming from, a country where I think rightly so, genocide denial is punishable, and I defend it very strongly also in my areas of jurisdiction at the international level, what would be at the domestic level the best criteria to determine from which moment on a crime is an international recognized genocide, war crimes, crimes against humanity, and when would be the criteria for a national penalization be fulfilled? Thank you.
Thank you, Prosecutor. There's a question in the back.
Mene kao žrtvu ne iznenađuje da se javio veliki broj ekstremista u Europi. Zato što je Europa dopustila da se na Balkanu vrijeđaju žrtve genocida, da se veličaju ratni zločinci, da se ponižavamo 28 godina. Europa ništa nije na tom pogledu uradila, ništa nije učinila. U parlamentu Europe sjedi Orban koji svaki dan šalje poruku nama žrtvama da nas vrijeđa, da nas ponižava i niko ništa.
Europe has allowed, over the past 28 years, a lot of extremists to show up, to continue insulting victims. And just as an example, Orban is sitting at a high political position in one of the EU countries, doing that on a daily basis.
Pored tolikih presuda, dokaza, u školama veličaju se ratni zločinci, škole se nazivaju po ratnim zločincima. Bošnjaci, djeca koja idu u škole u Republiku Srpsku, moraju da uče da je Karadžić, Mladić, narodni heroji.
Apart from all the evidence that has been collected and presented based on which the judicial decisions have been imposed, still in some parts of Bosnia and Herzegovina, schools are named after convicted war criminals. These people are presented as heroes, and children, the Bosniak children going to those schools, are basically forced to learn that these war criminals are actually heroes.
Europa to nijemo posmatra, ništa ne čini na tom polju i neka se nimalo ne čude ako postane 80% Europa, ako postanu svi ekstremisti.
Europe is silently watching this, doing nothing, and no one should be surprised if in the years to come 80% of people become extremists in Europe.
Europa je nepravedna prema nama Bošnjacima na Balkanu, ja to odgovorno tvrdim, a da je Europa nešto naučila, ne bi danas gorila Ukrajina i sve one scene koje su bile u Srebrenici, danas i ja gledam, nažalost, u Ukrajini.
And if Europe was at all responsible or held or behaved as responsibly, and I say this with full responsibility, we would not be watching things that we've been watching over the past year or so happening in Ukraine.
Kad budemo poštovali sve ljude koji se rode i koji imaju pravo na život, na vjeru, na školstvo, na zdravstvo, na sve ono što pripada ljudskom rodu, i kad budemo dijelili ljude po dobrim i lošim, onda će biti bolje i žrtvama, i ljudima, i Europi, i svijetu, i svima. Hvala.
If we manage to raise generations that will be respecting rights and freedoms and freedom of religion and everything else, will be better. And if we manage to get to the point where we divide people or differentiate people only based on whether they're good or bad people, everyone is going to do better, including us. Thank you.
Thank you very much. I'll very briefly take your question.
So last question, I'll try to be brief. Good morning to everyone. My name is Denisa Asko. I'm a prosecutor from Albania. I also take the stance that we should criminalize the denial or the minimization of genocide. And my point is that of course, during these years, technology has evolved and there's a rapid growth of the internet, who has given a platform to everyone for all conspiracy theories, all things denying scientific facts, especially denying and minimization of facts with the genocide. And my question was that having all this technology and using fake news and deep fakes and the waterfall spread of all this media around, soon it will come to the point that then we will not remember which is the truth anymore, because survivors will be gone with the time, and also there will come a time that usually we will think, and we will continue to think, that which was the real history, which was the real truth. And denying all this and giving voice to everyone, for me, it might have the counter effect of educating. So do we really want to have this freedom of speech without any limits? Because it's the other extreme. It's the censorship on one side and the freedom of speech without limits on the other. And if you, and with the involvement of the internet and the technology, we have seen that the freedom of speech have taken a new priority again, within the other freedoms, which are also very important, such as the right to privacy, for example. So I believe that this should be the stance that we should take into consideration.
Thank you very much. Yeah, and I would ask all of our panelists to reflect very, very briefly of 30 seconds because we are running out of time. But I can also combine that with a question that's come from online, rather holistic, which is how can we preserve the value of genocide prevention for the next generations? Would you like to start, Professor Strossen?
Start with the excellent question about technology, which was actually addressed in this UN and UNESCO report precisely for the reasons that the question so well articulates. It's going to be impossible to eliminate the supply of misinformation, disinformation, including Holocaust denial and distortion. And therefore, that is why this report, along with reports on social media that David Kay issued when he was Special Rapporteur at the UN, say we have to focus on the demand side of the equation. As with any prohibition strategy, trying to eliminate the supply is doomed to fail. That's why we have to inoculate people, so to speak, against the inevitable disinformation that they're going to be facing, no matter how much suppression you try to put in place, and why we have to emphasize media literacy, information literacy. If I may, on Dr. Bromwitz's question about how do you define punishable genocide, there is an inevitable slippery slope if you don't, I'm against criminalizing any idea or opinion, but if you're going to do it, I would certainly want to keep it as narrow as possible, including what has been found under international law. In France, in 1993, a respected Princeton professor was subject to 1 criminal prosecution and 3 civil injunction actions because he said while he was in France, yes, many Armenians were killed, but I'm not sure that it constitutes a genocide under international law because I'm not sure that it was an intentional strategy. And he was found culpable in one of those legal proceedings. So I think we have to cabin it as narrowly as possible, but there's going to be hydraulic pressures to treat many, many other situations as a genocide. That's a term that's being flung about right now. The Israelis are accused of genocide. Hamas is accused of genocide. And it's just going to, if we go down that road, there's going to be censorship of all kinds of legitimate historical and political debate.
Thank you very much, Professor Safferling.
Yeah, thank you. I would also like to comment on the question, what is a genocide, or what's a punishable sort of point of reference here? I mean, according to German law, that has only recently been amended in 2022, actually, to comprise more than the Holocaust, right, and other situations of genocide. Indeed, not only genocide, but also crimes against humanity and war crimes. So if you incite to hate by justifying or denying or trivializing those kind of acts, you're now punishable under the German criminal code. So that's extremely, extremely wide. And of course, the German courts, you might know, have a different approach to the crime of genocide compared to, for example, the ICTY or ICTR had. We have a much wider concept. So in 1994, even, we started to call the Bosnian situation a genocide, very broad terms, without, focusing on Srebrenica and other circumstances, too, in concentration camps. We convicted for genocide. Rwanda was accepted sort of as genocide by the Federal High Court of Justice in 2014, and then we have declarations by the German Parliament with regard to the Armenian genocide, the Yazidi genocide, but that has also now been declared as a genocide by the high courts in Hamburg and in other places. And just recently I was invited to discuss at the German Parliament whether the situation in China and Xinjiang would actually amount to genocide. So would that suffice, the parliamentary sort of declaration? I'm not sure, and that in that, Nadine, I would certainly concur that we need to keep this a little narrow. Thank you.
Well, 30 seconds, maybe. I think the others use maybe 90, but I hope we'll be as quick as I can. I really appreciate the question of the Albanian prosecutor, because I really do think we see the internet being used in intentional ways to prepare for violence and destruction of democracy in countries, as I described in, from the Snyder book about Road to Unfreedom. This is a plot and a plan, and we see it manifesting itself in all sorts of places. I mean, we do have to be aware of the fact that there's a battle going on. There's an old expression, don't bring a knife to a gunfight. Don't bring a speech to a ward of missiles, both those that are fired as part of preparing others to commit violence, and the physical ones that explode and tear apart human flesh, or the other kind of weapons that are used to kill people individually and cruelly, as we see in these genocides and other crimes against humanity. I think we have to be very vigorous and very tough using the tools of the law. And I think the law, in terms of the criminal law, is much better, looking very specifically at the context and looking at the ways in which the speech relates to conduct, and essentially convicting the conduct, but the speech as part of that conduct. And by doing that, give a warning to those that would engage in this kind of misinformation that they could find themselves in the same spot. And certainly, to the extent we're looking at prosecution standards and the ways in which cases are prioritized, to the extent systems permit that, then those are the kind of cases where I think we need to spend the resources. But do be aware of the fact that at the end of the day, if we in fact give up the free expression demand and mandate of our laws, if we give up on Article 19 or the First Amendment, we will find that the space for anyone to express themselves, any dissenting view, will quickly be eliminated. And I think we've got to be extremely protective of it by as I think, relating this to conduct or other lawless activity, in order to, but to be very tough about it in restricting these examples where speech is really intended to cause violence, genocide, and other unlawful violence. Thank you.
Before now handing over to Alexander, who will present the poll, let me just say thank you very much then to all of our panelists for a fantastic first panel. Thank you very much.
Thank you very much, Kiran. Thank you very much also to the panel from my side. If you felt the same as me during this panel, then I think we can agree that we could listen to this sort of conversation for days on end. Me personally, I can never get enough of this, and I'm glad we could have the panelists here discussing as they did. So before we head into break and return at 12 o'clock for panel 2, I would now like to have the results of the poll displayed. Well, that is quite the number. 83% of the people believe that freedom of speech unjustifiably infringes on free speech. Oh, it was just on there for a moment. Well, those that were quick enough to glance at view, it was 80% versus 18%. There we have it again. 83% of the audience thinks anti-denial laws unjustifiably infringe upon freedom of speech. The laws unjustifiably infringe. Is it unjust that they infringe? That's the logic. And exactly, and absolutely. So they essentially, yes, and so they essentially agree. Yeah, that's correct. Yes, absolutely. Yeah. With that, off to the break.